Yes, sir.
Now, so the only person here from last week was you, Jerome.
Yes, seems like it. Yes, sir.
Yeah, because then they must have missed out on the lesson that was there, which was about particular study methods and so on, which I'm not going to repeat, but I'm going to present it as we, go through some of the material. I will make reference to it, okay? Just see if I have it here. It's open. But there's the share screen, but I don't have the option to download from my PC. Okay. Very strange. So, guys, in any case, I to welcome you. I mean, Jerome already knows, what we've covered, just to the material. But, over this LLW, I'm just finding it very strange if you're delving into collective or individual labor law, without any understanding of individual labor law. If you guys have not done that, it's important that you understand what individual labor law is. It's really going to be work here. But this is the relationship between in LLW26. So, of course, focus was on that relationship as it exists between an employer, okay, on the one side, and the employee, okay, and was focused on sort of a narrow relationship of employment relationship. They have either few, very little employees and one employer. And you would delve into the nature of that relationship, how important it is, to distinguish between an independent contractor and an employee on the one hand, I just want to get perfect set. Basa, you read 2601 as well. Who is registered or who has already done 2601?
I completed 2601 last semester, sir.
So, okay. And Basa is now registered. He's doing it simultaneously. Lucky, have you done it already?
Yeah, I've done 2601 last semester.
Yes. Okay, good. So, yes, you can only do it simultaneously, I would imagine, or after 2602, after you have done 2601. So, recalling 2601, how important it is to be considered an employee because you get all the benefits and protection of all the labor laws, and how employers have actually over time tried to abuse the system to try and make people appear as if they were independent contractors, and making it difficult for people to prove that they were actually employees, and how the law changed. It made it a presumption now are considered to be an employee if any the court said over time he is an employee or an independent contractor in the LRA and the BCEA. It's section 200 capital A of the LRA 86 of the BCEA. Recall, guys, that the onus now moves on to the employers, regardless of the contract. That's just the thing. regardless of the form of the contract or what the contract may state. The law says until proven otherwise, if any of these factors are present, there's a presumption the person is not an independent contractor, but rather an employee, and it will then turn the onus on the employer to disprove this, giving sure protection to people to refer unfair dismissals or unfair labor practices to the CCMA. So that was the introduction of the Basic Conditions of Employment Act, the minimum basic conditions, the national minimum wage, the basic amounts of money certain categories of people, Basic Conditions of Employment Act, the minimum conditions. I'm getting a message that my internet. Are you guys? Can you still hear me? Because I'm getting a message here saying my internet connection is.
Yeah, you're kind of breaking up a little.
Yeah,
Breaking up a bit.
Sometimes.
Okay. Okay. Let me try something else. Okay, I hope I'm back. Can you hear me?
Yes, I can hear you.
It's clearer
Okay, let's
now,
hope this.
Brian.
All right, fantastic. Okay, fantastic. If there is an issue, please let me know. Then I can try and attend to it. But this is now the third time today it's giving me this message. So we looked at the Basic Conditions of Employment Act, the minimum, basic minimum terms of employment that are regulated, that won't allow employers to change terms of a contract, of an employment contract, to suit them. It has to be in accordance with the basic minimum. And you'll remember what the BCA regulates. It regulates your work hours, your lunch times, your leave, enforcement through labor inspectors, enforcement of through the labor courts if necessary, and eventually the prohibition of children working and exploitative practices. So the BCA, a very important piece of legislation. Then you will introduce to unfair labor practices, how an employer cannot discriminate unfairly amongst his employees. While they're working for him, they enjoy certain rights as well. Not to be unfairly discriminated against. There cannot be preference given to people simply because of either their race, their ethnicity, their gender, their religion, their sexual orientation, in respect of promotion, in respect of demotion, in respect of benefits. Okay, employee benefits cannot unfairly discriminate, except to the extent that the law permits discrimination in this area, and that discrimination, is namely. Is what? It's affirmative action. Okay, I'm just breezing through this because it's important that we understand all of this so that on a collective scale, because now we're dealing with these rights and all employees are entitled to these rights by law. But collective labor law is now this on a big scale. So coming back to, employment equity, that you can't unfairly discriminate, but the law does speak of the concept of affirmative action, which permits discrimination lawfully for a very particular reason, that is to address the past imbalances in the land and in the country amongst the race groups and previous, what we call PDIs, previously disadvantaged individuals, did not get opportunities, and they must now by law be given special opportunities and job opportunities to advance. Okay, and it's an obligation on employers, certain employers, that they do that they put such things in place and have an employment equity plan. Okay, and you also would learn about things like the right not to be unfairly dismissed, which is a large and a very, very important part of the of labor law. Okay, and it's all these things are linked to one another because it is the employment relationship. So you cannot just dismiss anybody. That's the whole thing. People tend to think that employers rather tend to think that they're entitled to treat workers just as they feel like and can get rid of them when they feel like it, and there's no legal basis for that. Okay, the labor laws, the LRA speaks of the employee having having the right not to be unfairly dismissed. The LRA says you can only be dismissed if there is a reason for it. That is known as substantive fairness, as you will recall, and there must also be procedural fairness, that the employer must also follow a proper process, and then only can he dismiss you. And the employee has he has recourse if an employer tries to abuse him in this regard. He can go to the CCMA, the Council for Conciliation, Mediation and Arbitration, or which is the General Bargaining Council, for employees who are not affiliated to any trade union or fall in a certain sector, who have their own councils, also known as bargaining councils, who pretty much do the same as what the CCMA does in a particular commercial sector. Okay, so that's the big one, that employees have that security. They cannot simply be dismissed, arbitrarily. It's a major thing, and it has got both a national and international import. Okay, it affects not only nationally here and in our country the employees, but it's got other impacts and outreaches to consequences outside of the country. It's good to have the right. It's good to have the right not to be unfairly dismissed, and that the employer, would have a hard time and a difficult time to get rid of an employee unless, the employee has really done something that is, recognized as wrong in terms of law and follow a procedure. So it's very hard to get rid of a person once he's employed and considered an employee. But from another point of view, and this will affect our discussion on collective labor law, is the fact that how does the rest of the world, or let's not say the rest of the world, but any other country that wishes to invest in our country, okay, and they see that what the labor laws are like, how difficult it is to dismiss employees, okay, and the rights that when these employees stand together, they become so powerful under trade unions. Okay, so that may discourage, perhaps we must consider that factor, that it might discourage outside investors from investing. Okay, we find all these investors, from China, from Germany, from Japan. They invest here, they want to put a plant here, create a plant here. It's very good. You can manufacture cars over here, in East London, those areas, Volkswagen, Mercedes, BMW. They're happy with it. They invest in here, but once they should once they take that, then they'll be hesitant to perhaps invest if they see that, well, it's so difficult and employees have all these rights. So it might have, that's one of the things it may have. I'm not saying it does have, but it may have an impact on any potential investor, whether it wants to come here when it considers the rights, the powerful rights that employees have. Okay, now that you dealt with in detail, guys, in LLW2601, we will make occasional references to that. So now imagine all of those rights, okay, that we mentioned in individual labor law now. In addition to that, we must now understand our move to collective labor law. And there's only a few units there's not many units, but if you understand them, then you'll be able to cover this work, in a short period of time. If you can use my cycle method, Jerome, you can recall the cycle method which we discussed last week about going through the work, not rather, one thing at a time over a period of time, but trying to go through everything at one go, so to speak, as many times as we can. And then build our knowledge and build our notes as we go through every cycle of all the units. So these 5 units. The first unit is the freedom of association, trade union rights and employers' rights. Study unit 2 is collective bargaining. Study unit 3 is the workplace forum. Study unit 4 is strikes and lockouts. Study unit 5 is pickets and protest action. So that is the things that we need to cover. But introducing this to us is we need to understand and to remind ourselves again of the Constitution. Okay? Now, when we speak of labor laws, guys, this term, labor laws, there's a lot of labor laws. There's a number of them. But which of those labor laws can anybody mention what is considered to be the top 4 or top 5 labor laws, the most important labor laws in the country? And at least for the purposes of this course and beyond, that you will require, some good grounded knowledge in these laws, have an understanding of them. Number 1 would be the Labor Relations Act. Number 2 would be the
Is it Basic Conditions of Employment Act?
Yes. And number 3?
Employment Equity Act.
Right, yes. Far-reaching acts, guys. Far-reaching acts, yes. And number 4? Okay, I'll mention it, is the Skills Development Act, Skills Development Levy Act, which is an act that encourages employers to take on, to develop skills within the workplace by creating initiatives, with the help of government to subsidize even the payment of people, to enter the workplace and to get them started to develop skills. So I'm an attorney, they will pay me. I want to get, candidate attorneys or article clerks to work for me. But for argument's sake, I can't perhaps include in my budget the salaries of 2 article clerks. I can apply through the Skills Development Levy Act, that through the Skills Development Act to get funding to pay and at least subsidize the payment of the salaries of these candidate attorneys. Okay, so there's many initiatives like that in various industries. Government is helping out. Okay. Okay, so those are the at least the 4 basic, important acts. There's other acts as well, lots of other acts, things like the Occupational Health and Safety Act, Compensation for Occupational Injuries and Diseases Act, which are add-ons, to the basic important ones, and these just give extra support to the employees and come to the assistance of employees when in the event that they should get hurt or injured, and also to give them a safe working environment. Now, the Constitution, over and above that, all laws are subject to the Constitution. Look, that's what the Constitution says, itself, that any law, any act, anything that's done, in government, it must be done, it must be in compliance and subject to the provisions of the of the Constitution itself. Right. Constitution Section 2 says that. Now, included in the Constitution, as you know, is the Bill of Rights. The Bill of Rights give various types of rights. And purposes of this course, of course, we should know that labor rights are also conferred on people. People have, individual citizens in the country have many rights. Rights of, freedom, dignity, equality. They've got socio-economic rights also, where the government is also required to provide certain services and things, within its limited resources. And included in that category is labor relations. Everyone, Section 23, subsection 1, sets it out here now. Everyone has a right to fair labor practices. Okay. Everyone has the right to fair labor practices. Now, what about, this would include all people. Now, we've seen, when we did in individual labor law, we had the case of illegal workers and foreign workers. Can you recall how those classes of employees, for example, the case of Kylie versus CCMA, who can recall there what happened? This person was a prostitute and she was involved in that kind of work, and she couldn't get protection under labor laws generally, okay? Because you are not an employee. That's not a recognized employment contract. You cannot be rendering services like that. It wasn't considered moral, but at the same time, she raised the point that, am I not then entitled to, everybody's entitled to fair labor practice? And the court agreed and said, we're not look at it's being done. We've been looking at the way this person is treated, even though it's not recognized under law what she's doing to be correct. She won't get protection under the LRA.
Mr. Alom, you're not available.
No?
You disappeared there for a moment, Mr. Alom.
Okay, no, it seems to be happening. Yes, I'm going in and out, but I'm back again, guys. It does happen occasionally. So in that case, yes, it said that the person won't get, Kylie didn't get protection under the under the LRA, the Labor Relations Act, or the Basic Conditions of the Act. But nonetheless, she's entitled, as everybody is, to fair labor practices. She can't rely on the labor laws, but she should be given compensation for what she has done there. She's done work, and and she should be compensated. The same with a person that is a foreign worker, is working here without a permit. Is not a citizen of the country and doesn't have a work permit. So now you employ that person as an unscrupulous employer, and you then turn around after the person has worked for you and say, well, I shouldn't pay you. You're not here even legally. You shouldn't be here, and I can't pay you. And I wouldn't have to pay you. Okay, it was the Discovery case where the courts used the same principle and said, yes, you're right, it's wrong not to, you can't employ somebody who's without a work permit, who's not a citizen in this country, and the person doesn't have a work permit, because if you do, as an employer, you will be in trouble. Right? You will have to pay a hefty fine, a very steep fine for that, number one. And number two, you're also correct that the person won't get the protection under the labor laws, so to speak, like the Labor Relations Act and the BCEA and the others. But the person would still be entitled to fair labor practices. And as such, the person can claim compensation from you as the employer that employed you illegally. So just to give you an idea how far these, constitutional labor rights go. Okay. Now let us further look at the Constitution. It also mentions here the rights of workers in section 23 subsection. And also not only the rights of workers, but also in subsection 3 of section 23, the rights of employers. Okay, which now we come into the backbone and to the main areas of collective labor law, starting to lay the basis for it, because all these rights, that collective labor law, where employees are organized, okay, they get in addition to that extra rights, which is given to them by the Constitution at the starting point, and then also further set out and codified in the Labor Relations Act and all the other legislation that affects them. So section 23, subsection 2 says that every worker has the right, A, to form and join a trade union. That's a constitutional right. B, to participate in the activities and programs of a trade union. And C, also the right to strike. So if you did not know, now you know. These rights are given to workers from the very top, from the Constitution. Okay, so these are your rights, broadly referred to as your freedom of association. Okay, that you can do these activities, and why I will come to it in a moment as to why, it was constitutionally enshrined. It's because historically the relationship between employees and employers were disjuncted. There wasn't fair. It was always the employer in the stronger bargaining position and the employees in a weak position. Right? And with the development of the country's history and so on, it was then made a point here. This was negotiated, when the Constitution was formed, and finally agreed to that, okay, we'll have to give workers these rights as constitutional rights. So what do they actually mean? To form and join a trade union and to participate in the activities and programs of a trade union and to strike. So these in broad terms are the rights given to workers, but what exactly is a trade union? How does one form and join one? How does one participate in the activities and the programs? When would the trade union come into being? How would it be operated? Would they have any rights in it? And will they represent all employees? So these are the kinds of questions that later on we will continue in study units 2 and 3, where this concept of collective bargaining and workplace forums come into being. And as we know, the Constitution only sets out the principle, guys. It only sets out, as it has here now, in very broad terms, every worker has the right to join a trade union and form one and participate in the activities and the programs and to strike. But now where the Constitution said so, Constitution only sets out the principle, but where are we going to find the deeper details about this right to form a union and participate in the activities and to strike? Where will we find that? The details about this particular rights given here.
I think it should be on the Labor Relations Act.
Yes, correct. Okay, now here we should note something, guys. It's correct that you say that, Lucky. The Labor Relations Act is the chief, piece of legislation relating to labor matters. And that is how the Constitution operates. It will set the principle, and leave it then up to the legislature, that is Parliament, to set in motion laws, okay, to give effect to this broad principle. Okay. Later on, you're going to come and see that how we interpret collective agreements and things like that, that we can't rely on the Constitution directly and say, well, that's the right to do this. It is left to Parliament to legislate, to set out the principle of the Constitution in detail. Okay? And that is how the labor relations came up. It was, created, and how it gets amended even afterwards. Okay, as long as it is in line with the principles of the Constitution. So all these things are in the laws that follow, primarily the Labor Relations Act. Yes. So the right to strike, you may think, is it an absolute right? I can strike whenever I want to. So just bear this in mind, guys. Every worker has got the right to form and to join a trade union, to participate in the activities and the programs of the union, the trade union, and also to strike. So that's the principle that has been set out. In subsection 3 of section 23 of the Constitution, that is in the Bill of Rights now regarding the labor relations, the right of constitutional labor relations, labor rights as we call it. It also now gives the rights of the employer. We've heard now what the employees are entitled to from the highest point, but from the Constitution, employers also have the right. What the rights do they have? Okay, because the law is given the rights to employees to join organizations, to form organizations, because there's unity in strength. Right? Is the employer going to be left like that alone? And also, what can he do? Does he have what rights is given to him? So the Constitution says every employer has the right, A, to form and join an employer's organization, and B, to participate in the activities and programs of an employer's organization. So, in as much as the Okay, can you all hear me there, guys?
Yes, we can.
Yes, you can.
Okay, sorry about that. There was a problem on this side. Sure, I'm happy we're still back here. Okay, good. All right, thank you for hanging on. Sorry about that. There was some issue here on this side, guys. So where did we stop? We stopped with the rights, the constitutionally provided rights given to employees and to employers. And just as employees have been given rights, okay, which are substantial, and the right to form unions and join them and to participate in those programs, employers have similar rights to form their own organizations. They may also join hands and to participate in programs, to give some, balance to the whole thing. So these are the rights that they have individually, and now the Constitution in Section 23, subsection 4, gives them rights, also sets out the rights and the principles and of the rights that they have together. Okay, so the trade union on the one hand and the employers' organizations on the other. They have a right to determine their own administration, to organize and form and even join federations. So trade unions can also join. Employers' organizations can join other employers' organizations, and trade unions can join with other trade unions. Now, what is the purpose, guys? I want to ask this to you. I haven't asked questions about it. What is the purpose of setting up our labor sector and our labor force in such a manner where on the one hand you give these rights to employers and to employees, and the employees got a very powerful weapon here that it can strike. And we're going to go in a few minutes' time. We're going to go into what it means, to strike and the in-depth concept of a strike and consequences. But is there really nothing else an employer can do? So employees can strike whenever they feel like it. Is what can an employer do? Is there nothing an employer can do, guys? Yes.
An employer can resort to a lockout.
Yes. That is it. It can lock out employees who are busy striking. So why is it been set up? That's the most powerful weapon the employer has, and the most powerful weapon if you can call it that the employee has is to go on a strike. But what is the point of doing all of this? Why has the law been set up like this in this sort of adversarial scenario? What is it? What is it encouraging or forcing the parties basically to do?
I think they are forcing the parties to come together and they resolve. I think they call it, I don't know the exact word, but basically an interest, the same common interest. Yeah.
Mutual interest, yes.
Mutual interest, yes.
Matters of mutual interest, yes. So the idea is, as strange as it may seem, well, it shouldn't seem that strange if we look in the workplace in our country and we see what's going on here. People striking, walking around, protesting, picketing, demanding things like, and it is actually legally, they may, under certain circumstances, they are entitled to such things. It is heard that they now. Okay. That they're entitled to strike. In some countries, if you strike, they'll shoot you, like China and some places like that. Yeah, our workers on the one hand, are basically, entitled to strike. Employers can, as a measure to counter that, lock them out and not let them come to work and not into the workforce and the work premises. The idea is, guys, that the law doesn't want to force people to, rather, it doesn't want to set certain things, things of mutual interest to the parties. It doesn't want to cast it in stone. It is hesitant to do that, very hesitant. It wants to let the parties come to an agreement amongst themselves. Okay. When we speak of trade unions, we speak of representative organizations, of many employees, at least a number of them, and their interests are represented at a level, and they engage the employers. Okay, and the idea is that they must come to agreement, and they can come to agreement on matters of mutual interest, as you mentioned. Wages, for example, the amount of the wages that must be increased by, as an example. And so it goes up and so it goes down between these two until they come to an agreement. And if they come to an agreement, this is where we come to the sphere of a collective agreement. It's an agreement that has been entered into between an employer or an employer's organization sometimes and a trade union representing mostly the majority of the employees. Okay. And different kinds of arrangements within the employees, which will come to these agencies, these forums within the workplace. There will be disputes amongst workers themselves as to who will represent who now in the trade unions. You may find groups that want one particular group to be the main majority trade union. You may feel others that they're not happy with that one and they want an alternative one. You may even find people that are not interested in becoming members at all. They may object, become what we call conscientious objectors to it, and because they're unhappy with the fact that the law gives all these powers, organizational and admin powers to unions, the LRA, depending what kind of union they are, whether they represent the the majority of the workers, in which case, if they are, then they get extra rights, organizational rights, and they can, up to a point, take money from your salary. They can, the employer is obliged to deduct that money and pay it over to the representative union. Okay, so that is how they get funded, and when they have this funding, they can run as an organization. So that is what we will go into later. But now we need to examine, considering that being now the premise, all right, of position now, that employees, they can strike, employers, they can form their organizations as well, and they can eventually lock people out. And this is where our conversation will now take a turn now, because if we understand this, then we'll have understood this whole course, hopefully, very quickly. So let us examine this, and I'm going to try and we'll start on this discussion, now, and see how far we go. And I will leave it just a few, unless these questions. Are there any questions, guys?
Not for me, sir.
Okay, anybody? No? Okay. Remember, guys, in my exercise last week, Jerome will know, the idea was that you go through everything and then you know where the end will be, rather than to do things piece by piece and not even possibly reach there should something happen. Okay, so you need to go through these things several times, and as you go through it several times, you go through the material, the unit several times, as quickly as you can, and you add notes to it every time that you go through it, and then you increase your understanding. So we come back now to the question of these two rights. Okay, the right on the side of the employee to strike and the right of the employer to lock out, force them to come to an agreement. So I think we just ended on signing agreements and a collective agreement. As powerful is the collective agreement that as a tool, as something that's mentioned in the LRA that says, you know, collective agreements will have a high position in labor relations. Okay, you can agree to things there. You know, you're doing it on behalf of many employees, some willingly and some unwillingly, the employees. But nonetheless, obviously, if you're going to negotiate as a minority or even as an individual, you won't get as far as a majority trade union could possibly get, right? They can negotiate many things of mutual interest. Many things, you know, they do come to agreement. So once they reach an agreement, that is known as a collective agreement, and it even supersedes other things. Okay, the law permits the parties to come to agreements in such cases, collective agreements, and it will take preference even over certain other things that the law just says. Okay, so the law likes to leave those things open for the parties to come to agreement to, and it will be a higher rank. Collective agreement, once is there, all the employees will be bound to it, irrespective. So, you know, the term strike, let's just look at that concept of strike. You know, do you know that the term strike has been defined in the Labor Relations Act? There's a section in the Labor Relations Act. It's more towards the back of this piece of legislation, at the section 213, and it defines strike as the partial or complete refusal, concerted refusal to work. Right, this is now a person refusing to work, or the retardation or obstruction of work by people who have been employed by the same employer or by different employers. So you don't only want to work, you refuse to work, but you are also obstructing it. You don't want it to happen. You don't want the employer to continue with its activities. You're encouraging others to do it. And you're doing it not because you don't like the fact that you've got a personal gripe with the employer, but it's for the purposes of remedying a grievance or resolving a dispute in respect of a matter or any matter of mutual interest between yourself and your employer. Okay, so this in essence is this definition. It's your refusal to work, and you're encouraging others also not to work for the purposes of remedying a problem that you've got, a dispute that you've got with your employer about a matter of mutual interest. And wage increases and wages are definitely matters of mutual interest, and it's the most common issue of mutual interest, okay, between an employer and employee. Not only that, but the amount. Normally it's about an increase in wages. The most common thing is people, having a problem with the employer because of the amount of increase in the wages. So we looked at it. We even looked at Section 23 of the LRA, where it said that yes, that is a constitutional right. But if you look at the definition now, refusing to work, that is, what is that? That is a ground for dismissal, because your duty as an employee must be to work. All right. So when we look at it from that point of view, if you refuse to work or follow instructions, you could face disciplinary action and you could even be dismissed. But because the Constitution gives this right, it is there now. Okay. Constitution, we heard there in Section 23, subsection 2, the rights of the employees. They can join, they can form and join it, they can participate in it. Now, that right, Section 23, subsection 2 of the Constitution, which is also loosely called the right or the freedom of association. That is all those rights of association, right, that we spoke of. To join, to participate in the programs, and even eventually to strike. Okay, and it is ingrained, and section, you cannot interfere with an employee's right generally as an employer with that right. If you are a pernicious employer or an employer that's trying to be disingenuous, you're trying to escape the rules, then you would not want people to tag up, to form teams and form groups and unions, because they would have a strong say and they would influence people in your employ, right? But you cannot do that. If you in fact take disciplinary action, even dismiss somebody, participates in a strike or involves himself in the activities of a lawful trade union, then that dismissal of that employee is what we call an automatically unfair dismissal. Okay? If you are doing that, there's a couple of what we call automatically unfair dismissals. You can recall that you did individual labor law, that it is automatically unfair to dismiss a woman who is pregnant. Because she's pregnant or thinking about being pregnant, whatever, then you dismiss her for that. It is automatically unfair. And who knows, when a matter is automatically unfair, what is the consequence for an employer then? Does anybody have any idea? For any automatically unfair dismissal, you could be ordered to, crazy things can happen. You could be, the employee could be reinstated, okay, which is like your standard remedy normally, according to the LRA. The employee could be reinstated, and you could, on top of that, be ordered to pay that employee up to 24 months, which is double the maximum. Normally the maximum is 12 months remuneration. But because it is automatically unfair, you would end up paying 24 months remuneration, double the time. And that is when you dismiss somebody for exercising his constitutional right to freedom of association, namely to form and to join a union, participate in the activities of the union and the programs, and thirdly, to strike. Okay? Provided, of course, that strike is a lawful one. We will come to that in a minute or so as to, strikes, how strikes are going to be, how should they be used? Because strikes are not normal things. It's not the normal way to resolve a dispute. If you've got a dispute, you don't normally just go and run out and start striking. If you do that, and if you don't do it under the prescribed legal procedures, there will be consequences for you. It can ultimately, there could be disciplinary action for you and will result in your dismissal. So while employees are entitled to strike, they must do that, this extraordinary remedy, after they've followed a particular process. Okay. But like I said, it's not the normal first stop when you come to have a dispute. So that being said, on the employer side, the employer has the right, as we said, to lock people out. And what does that mean? Also, again, we look at section 213 of the Act, the LRA, the definition section there. Section 213, which deals with definitions. And the lockout is defined as the exclusion by an employer of employees from the employer's workplace for the purpose of compelling the employees to accept a demand in respect of any matter of mutual interest between employer and employee. Whether or not the employer breaches those employees' contracts of employment, the cause of or for the purpose of that exclusion. So shortly stated, it's locking you out to basically force you to accept what the employer is saying. Okay, and this is where this power play comes in, as we spoke of earlier. That A registered trade union, a recognized trade union, is in talks with an employer or an employee's organization, depending, and the one will push the other. If we can't come to an agreement, then we can do strike. Well, you're locked out in if you don't accept that. And how long can it go on? And during this time, employee both are at a disadvantage. Both employer and employee are at a disadvantage. From the employer's point of view, the disadvantage is now that the workforce is not there. They don't want people to work. Okay, you know, you could suffer economically. Okay, that's the direct consequences for the employer, let alone the side issues, which we can come to later and see, you know, the destruction and the violence that normally accompany strikes, you know, can happen. So that is the one thing. On the other hand, the employee is also disadvantaged because while he's striking like this, the employee doesn't have to pay him. So he's actually losing out. So it's like a battle of attrition now. And you can't come to work until you accept my demand. Very well, we'll strike. And the idea is to push and force the parties to negotiate and to, you know, try and resolve the disputes and the grievances so that they can eventually come. This is what we call collective bargaining, so that we can eventually come to a collective agreement. Now, I mentioned now that, you know, you can't just go and strike when you like. There's certain requirements that must be met. But there are even circumstances, before we come to those requirements, there are also under certain circumstances when strikes are not prohibited at all. It's another exception. It's an exception to an exception. You know, and if the law is saying that, then there's also no right of lockout to the employer also. Okay, so when are those? What are those circumstances that you know, when a strike may not be permitted at all? Okay, and Section 65 of the LRA says that you know, no one can strike, no worker can strike, and conversely, no employer can invoke a lockout if the parties have agreed in terms of a collective agreement. You know, the collective agreement is that agreement that now takes preference over everything else between the employer and the employee. So if there has been a collective agreement between them, and the collective agreement prohibits a strike, obviously now, you know, the question can come then, can we enter into a collective agreement where we actually we agree not to have a strike? I mean, a strike is a constitutional right. Can we agree not to have that? So obviously there is certain concerns and certain limitations to that. Okay, so if they say they're not going to strike, they will resolve their matters either through, you know, through another means. It can only mean that. It cannot mean that you just abandon that right blindly like that. Okay? But if the parties have signed a collective agreement, it just shows you how you know, how high it had to be qualified to some extent. Obviously, you can only deviate from that if you know, it is better than the minimum right given to you. Okay? Just like in the Basic Conditions of Employment Act, it sets out certain minimums. Okay? The employer must, for example, you know, give you an hour lunch break, you know, a 30-minute meal interval or something, every few hours, or you know, it can do many things. You know, can't dismiss a lady for taking maternity leave, and for 4 months, you know, she's entitled to that leave, although by the minimum requirement under the Basic Conditions of Employment Act is that you don't have to pay the lady, she must claim from UIF, but there's nothing stopping you as the employer to pay your female employees who are pregnant for that period, you know, and some of them do actually do that. They're not obliged to in terms of law, but they still do it. So such a thing can be agreed upon. So a collective agreement again is between the trade union and the employers, and if they've agreed not to have a strike or lockout, then they would have to stick to it now. So that is one instance where it's prohibited to have a strike in terms of an agreement they have, or where they had agreement that when we have a dispute that we will resolve it through arbitration. Okay. So, and then also people who are working in certain industries. Certain people are working, in certain industries. Like, I mean, even the BCEA doesn't affect them. Like, if you work in emergency, essential services, basically, they may not fall under this category, and it would be devastating for them to go and strike. So they will also be excluded under certain circumstances. And obviously, whenever an employee decides to strike, or a trade union incites its workers or gets them to strike, when these prohibitions, like I mentioned, to strike, then that is what, and they decide to strike when they're not allowed to, we call that an unprotected strike. And what do you think happens with an unprotected strike? If you embark on an unprotected strike, what are you doing? What are you risking now?
I would say potential job loss.
Okay, who was first? Okay, who wants to go first? Because you were almost the same time. Okay, all right, Marcel, you go. And then Jerome can make comments if he wishes.
So I think that if the strike is unprotected, you may get fired from the workplace because the strike is unprotected.
Yeah. Okay. Remember, we know now what is an unprotected strike, right? A strike which the union has embarked on, where there has been a prohibition of that strike, right? Because perhaps they're in the essential worker sector, or there is a collective agreement in place, more importantly, right? It's basically saying, look, we agreed not to do this in our agreement. Yeah, you're doing it, right? This is essentially what it is about. So yes, so in the same way, an employer who locks people out also, when there's an agreement in place saying that they won't do it, is also acting unlawful. An unprotected strike means you got no protection now, because you're protected against an unfair, you're protected against dismissal. But an unprotected strike means you don't have protection, so the employer can now, take disciplinary steps against you. If you're out striking, but you should be working, you can't also, you must still follow a proper procedure. Now, what must an employee do, guys, to have this strike declared lawful and protected? There's a couple of steps. This is what they need to do. In terms of Section 64 of the LRA, they need to follow a process in order for the strike to be legally compliant and to be recognized. Okay, because if they are on an unprotected strike, they've got problems, as we just mentioned now. So when a party is in a lawful strike, then the employer can lawfully lock you out. Employer can't also just simply lock you out. Okay. Again, the question of the employer again, violating your rights of freedom of association, participating in trade union activities and striking. Okay. So in order, an employer also can't invoke lockout to an unprotected strike in that sense. There will be disciplinary actions that will follow. But an employer can only invoke lockout normally when the strike itself is lawful. Okay, so what must the employees, the trade unions do? And this is what section 64 of the LRA requires. Okay, it says that, look, when there is a dispute, it must firstly be referred to the bargaining council or the CCMA, if that is the case. Okay. Now, what do you think? If it is an employer and a trade union that has a collective agreement in place, it all comes down to the interpretation of that employment agreement. But now, for argument's sake, we're saying that in this case, what must workers do simply to make it a lawful strike? So they must refer it to the CCMA. And now, what does that word CCMA stand for? Who knows?
CCMA stands for Commission for Conciliation, Mediation and Arbitration.
Okay, sorry, I just was at, I heard that, I did hear that, was it Lucky that spoke there?
Yes, that's correct.
Was Lucky? Yeah. Yeah, right. CCMA, Council for Conciliation, Mediation and Arbitration. Now, this organization operates you know, for individual matters, individual labor law issues, as well as collective labor issues sometimes. Not most times, sometimes. Because the example of a council that has been created in terms of the Labor Relations Act, it says that, look, in employment matters, there's so many disputes between employees and employers. If they must go to the labor courts and to the normal civil courts or there to resolve their issues, which are just about labor issues, basically will take a very long time. It will cost the employees and a lot of money. So we're creating these councils, okay, which are dispute resolving councils, basically. Okay. The general one is the CCMA. So most matters, if you're not a member of a trade union or you don't belong in a particular sector, commercial sector is determined by the Minister of Labor, then you will go to the general bargaining. So what do they do there? But before we come to what they do there, now, what is a bargaining council? The CCMA is the example of that. I've told you in general terms what a bargaining council is, but there are many other bargaining councils in various sectors. The CCMA is sort of your general bargaining council. Okay? But in every sector, the transport sector, they will have a bargaining council. The banking sector is a bargaining council. So employees in that sector, they fall under collective agreement, and it can be decided through agreement between employers as well as with trade unions that we're not going to go to the CCMA. We're going to have our own little bargaining council here, and we will resolve all disputes here between our members and our employees. Okay. So the CCMA, as a general rule, they try and resolve a dispute, you know, through conciliation, through mediation, and finally through arbitration. So who has had the good fortune to be at the CCMA? Has anybody been there? Taken employers to the CCMA or taken there by somebody?
I have.
Okay, Lucky. What did you take your employer to the CCMA?
No, I was representing the employer.
Okay. So you must be, you were representing the employer?
Yes.
Okay.
Yes.
Now you see, that is interesting, you know, as mixed up as it is, at the CCMA, representation for employers are a bit easier because anybody, if it's a large employer, you know, can appoint somebody, a representative, to kind of appear there. You know, in small businesses, the employer many times has to appear himself, you know. So Lucky can be employed to go and appear there possibly, you know. It's even easier for an employee. Sorry, say again?
No. Actually, in actual fact, I was there as a witness on behalf of the employer.
Oh, okay. You was a witness only. Okay. Yeah. Look, guys, it's another thing. You know, I'll be on the CCMA on Monday again, representing somebody in an unfair dismissal referral. Okay. She's not a member of a trade union, but I'll be assisting her there. She's taken her employers to court for dismissing her unfairly. So what will happen? You know, the first C will happen: conciliation. The official at the CCMA will try and resolve the dispute informally with the parties and see if they can come to an agreement. If not, they will try and mediate as well, you know, give the parties advice and also do the same thing, try to come to an agreement. But if they are unable to come to an agreement, then the CCMA will appoint an arbitrator who will now hear the matters from either parties and, you know, almost like a mini court case, and hear evidence and listen to one side and listen to the other, let them produce evidence and make arguments, and at the end of the day make what we call an award. Okay, a decision about what should happen, and whether the employee who brought the matter there is successful in the referral, you know, hear what the employee wants. So that happens at bargaining councils as well, okay? But they deal only with matters within their particular sector. So Section 64 says that they must refer the dispute for conciliation. And now what happens normally, you know, okay, no problem, Jerome. No problem at all. Look, guys, we're meeting again on, it's almost time, by the way. So I think what we can do is we can call it, call it a day. It's 7 o'clock nearly. And we can close class there. What I want to tell you is, if you are finding this helpful, and perhaps you may even want to have what we call a session, you know, where you can come and make an appointment with me online like this, or through another means, preferably through this means actually, and then we can have another discussion privately about, you know, what difficulties you're having and how I can assist you, you know, with the work. Okay, so it's a free service. You guys must take full use of it. You know, and I can then assist you. Okay. I think it's nice if more people come together, you know, and we have bigger groups. But if you feel, look, there's something that you want to have assistance with, you tell me, make an appointment here like this, and then I can help you and assist you further. Okay.
Thank you, sir. Much appreciated.
Sure. Okay. You guys, yes, Celeste. Yes, Celeste?
No. I just wanted to say that's perfect. Thank you
Guys,
for
there's a
availing
request.
yourself.
Sure. That's the job, guys. Yes, Lucky.
Yeah. Yes. Thanks for the opportunity. I just want to thank you for presenting the course. But I just want to check: is this tutorial happening every Tuesdays at this time?
Yeah. So for now, yes.
Okay.
Okay.
Okay, no, thanks a lot.
But like I say, you can, we can arrange it even if it suits you guys, to another time. Or if I start off, these are like the standard Tuesday classes, but I would suggest that rather do it, sooner than later, because as we get closer to the exam, lots of people are going to want that time, and scheduling of times with students are going to be, tight. So I would say to you now, or, the earlier you start doing this, the better. Okay. So speak to Adele. Adele is here. She can give you this request form until I get my login credentials. She can arrange that with you guys. All right. Don't forget to sign the register or to add your student number in the chat box if you can't access the register. Okay, evening, guys. I'll see you next week then. Bye.
Thank you, Rayon.
Thank you.
Okay.
Thank you.
Thank you,
Bye-bye.
sir. Keep well.
Thank you.
Bye.
Bye-bye.
Ooh, Sisi. Did
Hi.
Rayon have technical issues?
Yes, he kept on cutting, but he would cut for a few minutes and then come back. But it wasn't as bad as Portia.
Okay. All right. Yeah, tonight was a difficult evening, eh? Thank you very much. I don't know what I would have done without you.
No, it's a
Now
pleasure,
go
Adele.
and rest.
And Owen, he wanted to speak to you, but then I told him no, you were busy with Portia. And he said then he'll speak to you tomorrow.
I'll go has he left now?
No, it's done. All of them done now.
Oh, okay. Okay.
So we're
I'll give
done.
him a thank you so much, Ndima. I really
All right,
appreciate it. Eh?
Adele. Okay, have a great evening.
Keep well. Thank
Bye.
you. Bye.